So what happens when a deal is done? The money's paid, but you find out later the whole thing was based on a lie. And what if it was a lie you kind of suspected all along? Well, this is the story of a pretty routine workplace injury claim that exploded into a major legal battle, going all the way to the Supreme Court. It forced a huge showdown over one simple, really powerful idea. Can a deal ever truly be final if it was built on a lie?
Right, so here's the puzzle at the very heart of this case. Zurich versus Hayward. Just imagine for a second. You settle a dispute, you pay out the money just to avoid a bigger fight in court, even though you had this nagging feeling the other person isn't being 100% honest. Then, later, you get undeniable proof they were totally lying. Can you go back and undo that deal? Or does the fact that you were suspicious in the first place mean you just accepted the risk?
Okay, so our story kicks off with a man named Mr. Hayward. He has an accident at work, and his employer's insurance company, Zurich Insurance, gets involved. What started out as a standard injury claim, well, it very quickly became anything but.
Now, according to Mr. Hayward, this was no small thing. He said his back injury was so severe that it had become a life-changing disability. He claimed he couldn't work anymore and needed someone to care for him all the time. And the price tag he put on all this suffering was pretty substantial. He was demanding over £420,000 in damages.
But right from the very beginning, there were two totally different stories playing out. On one hand, you had Mr. Hayward's official claim, painting this picture of a man with a really terrible, debilitating injury. But on the other hand, Zurich Insurance had him under surveillance, and their video showed something else entirely. A man doing heavy work at home, moving in a way that just didn't seem to line up with his medical claims at all.
And this put Zurich in a real bind. I mean, sure, they had video that strongly suggested he was exaggerating. But was it a smoking gun? Was it enough to prove outright fraud in court? They were facing a high-stakes choice. They could fight the claim and risk losing big, or they could just cut their losses and settle for a smaller but guaranteed amount.
And this is the number they landed on. Even with all their suspicions, Zurich made a pragmatic business decision. They agreed to settle the claim and pay Mr. Hayward just under £135,000, all to avoid the risk of a much, much bigger loss in court.
Now, the two sides signed what's known as a full and final settlement, and this is a really critical legal tool. It's designed to be the absolute end of the road. The whole idea is simple. Once it's signed, the book is closed, the argument is over, for good. Or at least, that's how it's supposed to work. But then, 2 years, 2 whole years after the ink was dry and the money had been paid, something completely unexpected happened. A new piece of evidence popped up from a source very, very close to Mr. Hayward. And you know what? It changed everything. The bombshell came from his own neighbors. They came forward and told Zurich that Mr. Hayward had admitted to them that he'd actually recovered from his injury completely. And not just recently, he told them this a full year before he ever took that settlement money. This wasn't just a suspicion anymore. This was the proof Zurich had been missing all along. So, armed with this powerful new evidence, Zurich went right back to court. Their claim? Fraudulent misrepresentation. But they had that signed settlement agreement staring them in the face. The critical question for the court was this: could they actually overturn a deal they had willingly made, especially since they were already suspicious from the start? The two sides laid out their arguments, and they were polar opposites. Mr. Hayward's defense was basically, look, you thought I was lying, you had your video evidence, and you settled anyway. You made a business decision. A deal's a deal. But Zurich fired back with an equally powerful point. Your deliberate lie is the reason we settled. Just because we were suspicious doesn't give you a free pass to commit fraud, and fraud unravels everything. You know, this legal question was so complex, so fundamental to the law of contracts, that the case just kept climbing up through the court system until it landed in front of the final decider, the UK Supreme Court. They were going to have the final say. And the Supreme Court's logic here was so methodical and clear. First, they said, the whole point of telling a lie is to get someone to believe you. But, and this is the crucial part, the victim of that lie doesn't have to prove they were 100% fooled. They just have to show that the lie was a major factor in their decision to make the deal. So Zurich's suspicion didn't cancel out the fact that Hayward's lie was still a key reason they paid him. And that, they said, was enough.
So the final verdict was unanimous and totally decisive, a complete victory for Zurich. The Supreme Court set aside that full and final settlement agreement. In the end, Mr. Hayward's payout was slashed to reflect only the injury he'd actually had, not the one he'd made up.
This case was about so much more than just one man and an insurance company.
It ended up setting a hugely important legal precedent about what happens when you're dishonest in legal agreements.
The legal tool the court used is called rescission. The best way to think of it is like a legal undo button. It lets a court basically pretend that a contract based on fraud never even existed. It just unwinds the whole deal and reinforces a core principle of the law, that binding agreements have to be built on a foundation of honesty.
So what's the big takeaway here? Well, for one, it means that a settlement can't be used as a shield for fraud. A liar can't just hide behind the argument of, well, you should have known better, or you suspected me anyway, so it's on you. This ruling confirms that when it comes down to it, the law will prioritize uncovering the truth over the finality of a deal, no matter how final it was supposed to be. So while the law is now crystal clear for victims of fraud in cases like this, it does leave us with a fascinating question for our own lives, right? When we're making our own deals, whether it's buying a car, signing a contract, whatever, where do we draw that line between just healthy skepticism and the kind of hard proof that tells us we need to walk away?